I'm Nicole from Low Income Relief, and today I want to talk to you about what CPS can and cannot do. This is a question that we get asked quite a bit because a lot of people tend to confuse poverty with neglect, and we know that those aren't the same thing. You're doing the best you can, and times are tough, and sometimes that has some seriously unintended consequences. So, just so you know, when Child Protective Services comes knocking, it can be a terrifying experience, even if you've done nothing wrong. I know this firsthand because I've had that visit happen a couple of times. And you can take comfort in knowing that 80% of reports are deemed unfounded. That means they don't really go anywhere. Knowing your rights is essential to protecting your family. You need to know what they can do, what they can't do, and what you can do as well. Now, I'm not a lawyer or a social worker, but I have researched this topic extensively. I've had many personal interactions with CPS. I've consulted with legal and social worker professionals, etc. So let's carry on through this list. So, what CPS can do? It's important to understand what they can and can't do, but I think we're going to start with what they can do. And I know it's normal and natural to feel defensive and shaken when they show up at the door. It means that someone made a serious accusation about you or your child. That's distressing, but you need to take a deep breath and think critically about what is happening. All right. So let's start with what they can do. They can investigate all reports. They can investigate any report of potential child abuse or neglect, even if it seems unlikely and even if it turns out to be false. CPS can show up unannounced. They may visit your home without prior notice as part of their investigation. CPS can add new concerns to the allegations. So if they're investigating and they find new issues, they can incorporate those new issues into the case, even if they aren't relevant to what started the original investigation. CPS can interview your child without your consent. They can talk to your child privately and ask detailed questions, even about topics that seem unrelated to the original report. They may photograph your child as part of their investigation, and they can do that without your consent. CPS can interview others. They can speak to teachers, family members, or anyone else that may have information about the case. CPS can use your statements. They can use anything that you say as part of their investigation. CPS can collaborate with other agencies. They can work with law enforcement, medical providers, and other organizations. CPS can demand that you follow a plan. This is one that we get asked about all of the time. CPS can create a safety or a service plan with steps that you need to take, such as attending parenting classes, undergoing drug testing, or seeking counseling. They can do this even without a court order, and if you don't comply, they can report that noncompliance to the court. CPS can remove children from your home. They can only do this if they have a court order or if the child is in imminent danger. Imminent danger usually includes the risk of physical harm, sexual abuse, neglect, or other serious threats. CPS can ask the court to terminate your parental rights. This is a lengthy process. It is not something that happens overnight, and it usually is considered only as a last resort. It requires court involvement and can take 18 months or longer for this to happen. CPS can offer financial assistance. This is one that a lot of people don't know, but CPS may have access to special funds or assistance programs that can help your family meet immediate needs or get the things that you need. This is one of the upsides. I know that it's frustrating that so many people confuse poverty and neglect, but it can unlock extra assistance programs for you. In other videos on the main channel, I talk about how CPS actually contributed $500 to our insane $3,364 power bill that we had once. You can go check out that other video for more information on that, though. Now, of course, there are potentially big consequences here. It's important to understand that if a CPS investigation finds evidence supporting the allegations, it can have long-lasting consequences, and those consequences can go far beyond the scope of what you might expect. This could even include impacts on your future employment. I once knew a woman who lived through this. Years before I met this person, when she was very much younger, she had a child removed from her care by CPS. By the time I met her, she'd made a lot of improvements to her life. She was raising two new wonderful little girls, but she was still unable to work at child care centers because of her history with CPS, and that showed up in her background check and kept her from getting that work. So just so you know, the consequences can be big and they can go beyond what you might expect. But now let's talk about what CPS can't do. The first time I was contacted by a CPS caseworker, I had no idea what the rules were. I had no idea what their limits were. I had no idea what they could do. I assumed that they had all the power and authority that they claimed to have, but I was wrong. I have since learned some very valuable lessons about how this works. And I think it's really important that you know your rights so that you know how to advocate for yourself and your family. So let's talk about some things that CPS cannot do. CPS cannot tell you who made the report. Reporters of suspected child abuse or neglect remain confidential, although they may be called as witnesses in court if your case gets that far. That being said, I've been able to deduce who's called on me in most cases just because these circumstances made it pretty clear what was going on. CPS cannot force their way into your home without a warrant. You have the right to refuse entry unless they have a warrant or unless they witness an imminent threat to your child. CPS cannot force you to take a drug test without a court order. If you refuse to take one at their request, they must obtain a court order to compel that drug test. CPS cannot offer you legal advice, and they cannot arrest you. They are not lawyers and they are not law enforcement. However, they can contact police if they suspect criminal activity, and if they contact the police can arrest you. CPS cannot make final custody decisions. They can petition the court to make certain changes and they can make suggestions to the court, but ultimately the decisions rest with the judge. So please note that some of these specifics may vary slightly by state, but extensive research and consultations with different professionals have shown that these limits generally apply nationwide. So with all of that said, what can you do? Now that you understand what CPS can and cannot do, you might be wondering what you can do about it. After all, the investigation can feel very overwhelming, and it can be hard to know how to stand up for your rights in a responsible way. Ultimately, you can take comfort in the fact that the vast majority of reports, over 80% of all reports, are deemed unfounded. That means they don't go anywhere. That means they conclude that the investigation or the complaint didn't have a foundation. There was nothing to it. And I find that very comforting. I'm sure you do as well, because that means that in most cases, it's just going to blow over. But in the meantime, there are some things you can do. The first and most important one is that you can demand to know the specific accusations against you. You have the right to know what was reported. And don't be afraid to escalate to a supervisor if the caseworker doesn't want to give you that information. I had that happen once. Somebody came out to my house. They wanted to investigate my family, and she would not tell me why. I later found out that one of our neighbors had called in and said something about animal feces in the house, but we didn't even own any pets. So it was pretty clear right off the bat that that was not real. But I had to, after she left, I had to call her supervisor and really push for that information because nobody wanted to tell me what was going on there. So don't be afraid to escalate to a supervisor. You have the right to know what you were accused of. So going on with what you can do, you can insist on an interpreter if you are more comfortable in another language. Many, many documents from social service agencies state that you should never let your child act as an interpreter for you. That's a lot of pressure to put on a kid. It's not really fair. So you have the right to refuse to let your child interpret for you, and you have the right to have a different interpreter involved. You need to make sure that you exercise that right. You have the right to refuse entry into your home. This prevents them from gathering evidence, adding new things to the complaint, or judging you based on a quick glance that might be interpreted. You also have the right to seek legal counsel. An attorney can protect your interests and guide you through the complex legal process. If you can't afford an attorney, there are legal aid agencies that may be able to assist you. We have a list of legal aid providers at lowincomerelief.com/legal-aid. And of course, you have the right to refuse to answer questions. I know it can feel awkward, but you don't have to justify your refusal. No is a complete sentence. You also have the right to pursue placement instead of removal if it comes to that. If your child is removed from your care, you can ask the court to place your child with a trusted family member or a friend during the investigation. And of course, you have the right to attend all court hearings about your case. You can also bring your attorney. Your presence ensures that your voice is heard in decisions that will affect your family. And if it comes to that point, it is very important that you do attend those hearings. Now, of course, like I said, I am not a lawyer. I am not a social worker. I'm just a researcher who spent a lot of time looking into this, and I've talked to a lot of people and been through it a few times. But it's always best if you can speak to a lawyer about your unique case. If you would like to consult with an attorney, there are a few ways that you can get help. You can visit a free legal aid clinic. We have a list of those around the United States at lowincomerelief.com/legal-aid. You can also visit an attorney with a free consultation. Many family law attorneys provide free 30-minute consultations. I've done this. I found it very helpful. So that's something that you may want to consider. You can also ask a lawyer online. If you have a specific legal question, our sponsor Just Answer may be able to help you get those answers for less than you would pay going to see an attorney in town. So you can ask their legal experts questions anytime, day or night, for a very low cost. You can visit lirlinks.com/justanswer to get started with that. And of course, for more ways to get help, visit lowincomerelief.com or check out our other videos for more ways that you can save money and get free stuff.